going to show you now a particular skill which is known generally as skim reading. So I've given you one example of a case, and you might be asking, but hang on, is all this reading? And you'll see there is a lot of reading. This is law, all right? But there's a shortcut. It's called skim reading. So what does that mean? The skill is that you don't read the case from beginning to end. What you do is you look for headings, or you read the first sentence of the paragraph, which looks like it might be relevant to the reason you're reading the case. You scan for key words. Basically, skim reading allows you to categorize each paragraph or section about this is about the facts, this is about the law, this is about the application, etc. So it's a very important way to get through a lot of documents very quickly, and then to find what you're looking for. Now, I'm going to show you how to do this. Read the Bayete case. We've read it a few times. I hope you have. I did read a lot of it with you, so in a sense, I'm kind of, to some extent, I'm kind of recovering or going over what I have covered, but I'm doing it from a point of view of now learning a further skill. We take the Bayete case and we say, okay, so exercise 4 is what I'm talking about, okay? Read the case, summarize what which paragraph is about, 1, 2, 3, etc. What is 1 about? I would help you by saying, well, it's just the introduction. Something like that would be perfectly. What am I trying to get you to do? I'm trying to get you not to read it word for word. Yes, I know we've done that, but I'm wanting you to see how to quickly skim through this. Because if you pick up this now, and yes, you're going to have to practice it, but I'll show you. You pick it up now, you'll be able to get a very quick idea from case law what it's about. So let's go through each paragraph. Paragraph 2, the facts. I've explained that already. But I hope you see, I'm spoon feeding here to some extent because I've highlighted the word facts, I've explained it, etc. But if you had to summarize what paragraph 2 is about within a sort of legal framework, you would say, well, it's the facts of the matter. I hope you see that. Next one is paragraph 3, all right, sort of the facts of the matter, how the case was prosecuted, processed, and the applicant's case, etc. Then the law, the paragraph 4 is the law. I've already explained that to you, and you'll see that how do you get to see, well, this is the law? Well, one way is they quote the actual law. So in the first sentence there, it says, on the ground specified in item 2.1 of Schedule 7. I've said to you, that is referring to a particular part of the Labour Relations Act as it was at the time. Okay, so one way to see that, and if you start to read the judgments, you will see very quickly where the law is, because they literally say, okay, this is the section of this act, this is the section of that act, and so on. As well as in the law, by the way, is also, as in this Bayete case, is also the judgments that are referred to in that particular judgment. Paragraph 5 is the application of the law to facts. So to summarize it, to put it, to skim it with the idea it's the law to the facts. Okay. Now, application of the law to facts. 7, application of the law to facts, and 8, finding on the first claim, and then the second claim, dismissing it. Okay. So that is the or judgment, if you like, on those claims. All right. Now, it might seem very simple at this stage because to some extent I've kind of covered this with you, but I thought I'd give you this sort of or use what you've already done to show you that that will illustrate the skill to you, and then the judgment. Okay. So now let's move to exercise 5. Now in this case, you're going to read a new judgment. It's an arbitration award that I did. I've changed things, okay, names and that kind of thing, but I thought it's just an example. So right now, you need to make sure that you've downloaded that. Now, you don't have to print it out or otherwise, but printing it out sometimes does help. So what I want you to do now is then do this exercise, read that arbitration award, and I'm wanting you, I'm wanting you not so much to look at what is said, but look at a paragraph and say, what is this about? Is it an introduction? Is he dealing with the law? Is he applying the law? Whatever. Okay? So particular, looking for facts, looking for the issue in dispute, looking for the application and the conclusion. All right. So please stop the video here and read that with that in mind, and then we'll come back and we'll discuss it. So you've got that award and you've read it, and now, as I said, we unpack it for looking at the paragraphs and saying, what is it about? Well, it's pretty easy in the sense that it kind of tells you what it's about. Paragraphs 1 to 4, well, the heading is details of hearing and representation. Paragraphs 5 to 6, the issue to be decided. Paragraph 7, the background to the dispute. Paragraph 8, the survey of evidence. Okay? And then paragraph 8 and 9, sorry, just do that. 8 and 9 is survey. Paragraph 10 and 11 is the respondent's version. Okay, so the applicant's version, 8 and 9. So this is the evidence now that was led. 10 is the respondent's version, and then what have we got? 11, 12, 13, etc., etc. So I'd say to you, this is not difficult. You see the paragraph analysis of the law of evidence, paragraph 17, set out the law. Okay, and let's just read that a little bit. Sorry, I just want to move this a bit. The form of misconduct Ms. Haddon is alleged to have committed, and the reason for dismissal is what's referred to as derivative misconduct. I quote my own book there, Practitioner's Guide to Unfair Dismissal. So what am I doing there? I'm summarizing the law. And then application of the law to facts. Okay. The evidence is that Ms. Haddon was made aware of the information pertaining to potential scam. She conceded that the word scam implies some unlawful conduct. Her defense is that she did not have anything to report, or that there was nothing to report. In the light of the information she was given, she has a duty to report what she was told. The evidence is that she did not report anything but discussed what took place with other employees. I find that she's breached the law there. Okay, the workplace rule, should I say? And there's other issues that arise there: workplace awareness of the rule and the bias of the chairperson, etc. And then the award is the application is dismissed right at the end. Okay, so yes, this is quite easy. Okay, you'd say, well, really, what's to learn here? I've made it easy because it actually becomes quite difficult. When we start doing this later, we'll do this in another context where I show you how to research law. You'll see that it's not quite as easy as that. But often, in the best cases, when the judges that write the best judgments follow FELAC, and they will say something like facts of the matter, or applicant's version, applicant's case, respondent's, and then they will go through. So if there was an award, they'd look at the CCMA award, and then they'll look at the Labour Court, and they'll look at the Labour Appeal Court, and they'll set it out in a very logical way, always setting out the facts, setting out the issues, and setting out the law as we go through it. Generally, it's written like that. Now, what I've given you is an arbitration award. Now, I haven't been a CCMA commissioner for some years, but actually what you've got, if you think one day you are an arbitrator, you've got an outline for a classic arbitration award in that format. What you've also got is you've actually also got the outline of the finding if you chair disciplinary hearings. that is a classic type outline that you've got. Why? Because it follows FELAC. Even if people don't say, oh, never you use the term FELAC, what you find is that that's how lawyers will work. That's how I want you to start to think through these problems that we come across in our workplaces. Great. Now you've finished module 2. I would like you to do a quiz, a little test, just to check your knowledge. If you have a look, it's very simple, true and false, a couple of multiple choices. The point of that is just to reinforce your understanding. Check your understanding, reinforce your understanding. Obviously, you don't have to do it, but if you're wanting to get the certificate, then you need to do that. All right.